And now I get to introduce myself. Hello, my name is Beth Anz, and I am your director here at UCB. And we are talking about what you should know about the Johnson Amendment. Lots to know, lots to learn. Let's dive in. So we're talking kind of politics today. We're going to talk about politics, about nonprofits, about the fundamental principle of the separation of church and state, and what something called the Johnson Amendment has to do with any of it. So the Johnson Amendment has been in the news recently. You probably missed it because there's a lot of news going on right now, but it's important to know. So we're going to share with you today what you should know about the real rules of engagement with social action and with politics. So we're going to dive right in. First, we're going to talk about the separation of church and state. Now, this concept of the separation of church and state, I'm sure you've heard this phrase, it goes back to 1791. That's when we ratified the Bill of Rights. So the First Amendment states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of people to peaceably to assemble and to petition the government for a redress of grievances. So it's not explicitly stated in the First Amendment. The clause is often interpreted to mean that the Constitution requires the separation of church and state. Roger Williams, who is the founder of Rhode Island, he used the metaphor of a wall or a hedge of separation between the wilderness of the world and the garden of the church. Now, Williams believed that any government involvement in the church would corrupt the church. Now, he was banished for preaching these ideas of religious freedom, and he helped establish in Providence a government with unlimited power that only addressed civil matters. This was a big deal. This was a revolutionary concept at a time when many governments were established with divine rights of leaders to rule, and it was influential in establishing a democratic governance of our new country. So this brings me to my favorite story, the Cheshire Mammoth Cheese Wheel. Anyone heard this one before? No? Oh, this is a fun one. So Thomas Jefferson and James Madison of Virginia fought against state support and taxation of the Anglican Church, which had long been established in the colony. They argued that compelling citizens to support through taxation a faith they did not follow, this violated their natural right to religious liberty. They were supported by several denominations, like the Baptists, the Presbyterians, and the Quakers. This helped support the addition of religious liberty in the Bill of Rights. So this influenced it. In 1802, in appreciation of his support of religious liberty, the Baptists of Cheshire, Massachusetts, made a mammoth cheese wheel. It was made by, and it's mammoth, it was made by freeborn farmers, their wives and their daughters, so all free labor. It had the milk of all 900 cows in the county. It was formed in a 6-foot cider press, and it had engraved on it, "Rebellion to tyrants is obedience to God," which was Jefferson's personal motto. It weighed 1,235 pounds, and it was delivered in a wagon drawn by 6 horses. Now, Jefferson, by policy, refused gifts while in office, so he paid the Baptists $200 for the wheel. Now, here's a fun fact. With their recent discovery in the New World, this marks the first recorded use of the word mammoth to describe something large. A local newspaper joked that the bakers in New York were now creating an oven to make a giant loaf of bread, and glassblowers were making a giant wine bottle for a fine American porter. It remained at the residence for several years. It deteriorated in quality quite a bit over that time, and reportedly, it was dumped in the Potomac River sometime after 1805. It was probably pretty stinky at that point. So that is the Mammoth Cheese Wheel, my favorite story of religious liberty. So we've established that the First Amendment is interpreted to mean that the Constitution requires the separation of church and state. But as we know over time, these laws require interpretation by the courts. So this brings us to post-World War II in America and the public school religious education. There's a couple of noteworthy cases for this interpretation. I have 2 up there. First one is Everson versus the Board of Education in 1947. A New Jersey statute gave school boards the authority to reimburse parents for the cost of busing their children to private schools. This included Catholic and other parochial schools. Everson, a taxpayer, challenged this law as impermissible expenditure under the Establishment Clause. The Supreme Court ruled as constitutional because it did not breach the wall of separation between the church and state, and he held that the Establishment Clause of the First Amendment applied to state and local governments as well as to federal government. This is the first time it applied to state and local governments as well. So this set a precedent. Justice Hugo L. Black stated, New Jersey cannot exclude individuals because of their faith or lack of it from receiving the benefits of public welfare legislation. Another pivotal case you may have heard of, you may know it as the Lemon Test. In Lemon versus Kurtzman, 1971, the court established three-pronged test. Organizations must have a secular legislative purpose, must have principled effects that neither advance nor inhibit religion, and it must not foster an excessive government entanglement with religion. So this was for a long time the test for the separation of church and state, until very recently. This was abandoned in 2022, is currently interpreting the Establishment Clause by reference to historical practices and understanding. This came about with Kennedy versus Bremerton School District in 2022, upholding the rights of a public school football coach to offer a prayer on the 50-yard line after a game. This established the principle that neither teachers nor students shed their First Amendment rights at the schoolhouse gate. So as you can see, these are a couple examples of how the separation clause has been interpreted differently by different times at different people. This brings us to the Johnson Amendment, as I talked about earlier. What is the Johnson Amendment? So as I said earlier, it's been in the news recently because of the recent changes of how we interpret it. Again, that interpretation is changing, not the law itself, the interpretation of the law. The relationship between church and state, well, it's complicated, and you've probably heard people say that nonprofit and church organizations must be nonpartisan or not engage in politics. This is the amendment, this is where it comes from, that establishes those rules. And as you've seen from previous cases, it's open to interpretation. So let's get into it. What is the Johnson Amendment? The Johnson Amendment is a provision in the U.S. tax code. So it's in the tax code. It's been there since 1954. It was non-controversial at the time. It prohibits all 501c3 nonprofit organizations, of which churches are, from endorsing or imposing political candidates, ranging from charitable foundations to universities and churches. The amendment is named for then Senator and then future President Lyndon B. Johnson of Texas, who introduced it as a preliminary draft of the law in July of 1954. Currently, the law prohibits political campaign activity from charities and churches, defining as a 501c3. The organization is one which does not participate in or intervene in, including the publishing or distributing of statements of any political campaign on behalf of or in opposition to any candidate for public office. So what can we do? Churches and 501c3s organizations can engage in a limited amount of lobbying, including ballot measures, and advocate for or against issues that are in the political arena. The IRS has provided guidelines on this regarding the difference between advocating for a candidate and advocating for legislation. So in simple terms, we like to say issues, not parties. That's the simplest way to look at it. So what changed and what did not change? So what changed? This goes back to the first President Trump administration. In May of 2017, by executive order, he signed an executive order directing the Treasury Department to avoid penalizing religious organizations for engaging in speech about moral or political issues from a religious perspective. What changed recently, July 7th, 2025, in a court filing, the IRS carved out a significant new exception to the Johnson Amendment, saying churches are allowed to endorse political candidates in their usual channels of communication with non-related tax-related consequences, in other words, from the pulpit. Religious services concerning electoral political viewed through the lens of religious faith, it neither participates nor intervenes in a political campaign within the ordinary meaning of these words, is what the filing said. The filing was part of a joint motion by the IRS, the National Religious Broadcasters, and 2 Texas churches to settle a lawsuit through a consent judgment. So what didn't change? Repealing the Johnson Amendment would either require an act of Congress or the Supreme Court ruling that the law is unconstitutional, and neither of these possibilities have occurred. So the law itself remains in place. The IRS does not have the authority to repeal legislation like the Johnson Amendment through a consent judgment. Therefore, there have been no changes to IRS policies or the laws governing political activity for nonprofits have been finalized or fully enacted. So nothing has changed, just their enforcement of the law has changed. Why did it change? Who advocated for this? Starting in 2008, a group now called the Alliance Defending Freedom, which worked in recent years to help overturn Roe v. Wade, tried to manufacture a court challenge to the constitutionality of the law. They organized pastors to speak about candidates and elections from the pulpit. The plan intended to provoke the IRS into a legal confrontation, so they were pushing for this. Churches speaking out of violation of their tax-exempt status. Among the advocates of that plan was a name you may know, Mike Johnson. They're then a conservative lawyer and now the Speaker of the House. He said, "I think we would defend this as a constitutional right to free speech." He said this in 2008 about the effort. Over 4 years, the group organized some 4,000 pastors to the campaign, including some who sent their sermons to the IRS by mail, inviting them for a crackdown. Oh, wrong button. So where does the UUA stand on this? This is the UUA and Side with Love, which is our advocacy group, response. Our sacred duty is to protect democracy and religious pluralism. We affirm commitment to the separation of church and state. Their statement is, "Our faith has a long history of faithful statements and resolutions that unequivocally support the separation of church and state. As such, we are deeply concerned by the IRS's actions, which would further erode this fundamental principle and democracy itself. The UUA maintains adherence to this principle and calls on all people of faith and conscience to uphold this cornerstone of democracy. Our shared values of pluralism and interdependence mean that a multiplicity of religious voices must thrive for our nation to remain on solid ground. And as we face a rising tide of authoritarianism and the infiltration of the white Christian nationalism into government and public policy, now is the time to reassert these values." We understand that religious institutions and congregations play a role in shaping and advocating for the values and principles of our members. Values that will in turn shape the public square, the democratic process that UUs hold sacred, and the public morality that helps guide this nation. We believe these are appropriate roles for UU congregations and all religious organizations to play. What is not appropriate is for religious leaders to use this authority invested in their status to endorse political candidates. To do so becomes a corruption of the religious leader's role, and in fact harms our ability to help guide these people who turn to us for guidance and support. So very similar to your cheese-loving Baptists in the beginning, that hedge of separation of church and state. So let's make it simpler. First of all, there's some great resources on the UUA website on how to be prophetic and not partisan. And if you really want to dive into what you can and can't do with specific examples, The Real Rules is a handy guidebook that is found on the UUA website. It shows appropriate political activity and justice organizing. It details almost every scenario you can think of. So when you ask, can I do that? It has an answer. But here's the basics, broke down into a very basic list. So what's allowed for a 501c3 organization? The UUA, UU congregations, and organizations can engage in issues, advocacy, and organizing for justice, can conduct voter education, can conduct voter access through voter registration, can get out the vote drives, can combat voter suppression, can support or oppose ballot initiatives, can educate candidates on issues. They can sponsor candidate forums. They can prepare and distribute nonpartisan voter guides. They can lobby elected officials, and they can host a variety of activities at the organizations, at the congregations. So what can we not do? Congregations cannot have advocacy as their only activity. So Sunday service is actually somewhat of protection for us because it says that we have a service outside of any advocacy that we do. We cannot endorse or oppose candidates running for elected office. We cannot intervene in campaigns to influence the outcome of election. So again, issues, not candidates. So that's the basic can and can't. Progressive people of faith can be powerful and prophetic without being partisan. We can engage our neighbors, we can educate our communities, we can mobilize voters, rally around ballot initiatives, and shape the public discourse with values-based framing rooted in our theology and principles. Electoral cycles often heighten opportunities to engage and inspire people and mobilize around key issues and to strengthen our democracy and win real advances on key issues of the ballot. So what do we do as UUs? How do we side with love? Side with Love is our UUA Action Center, the shirt I'm wearing today. And there's some examples here of the ways the UUA encourages us to engage with political issues. They have a lot of great resources. These are all on their website as well. They state our intersectional justice priorities are climate justice, inclusive of indigenous sovereignty and climate resilience. We do that through our Create Climate Justice initiative. Democracy and electoral justice, inclusive of voting rights and the electoral participation, through our program called You the Vote. Decriminalization, inclusive of racial justice and immigration justice, and this is through our Side with Love. And LGBTQIA+ and gender justice, inclusive of reproductive justice and abortion access, that is through the Uplift Action. And all of these fall under the Side with Love umbrella. So if you go to their website, they will have great resources on how to engage in these issues within our community. And the work we do together to build a world in which all of us are free and thriving is interrelated. When we ground our spirits, grow our skills, and act strategically for justice in deep relationships with each other and our movements, we choose to side with love. This action center is a place where we unite and work towards a world where we all thrive. And together, when we take action, side with love, and make deep impacts in this critical moment. So now we're getting down to it. This is from the ACLU. Now you know what you can fight for. How do you protect yourself while engaging on these issues? These are basics from the ACLU. There's a short and a longer version on the screen. These can all be found at aclu.org. You can download these slides at aclu.org. I'm going to read you the short one. So know your protest rights. You do not need a permit to protest in the streets or on sidewalks if you're not obstructing traffic or access to buildings. So as long as it's not obstructive, it is legal on public property. You have the right to photograph anything in plain sight. That includes the police. So let me say that again. You have the right to photograph anything in plain view. That includes the police. If you're stopped by the police, ask if you're free to go. If yes, just calmly walk away. If you are arrested, ask for a lawyer immediately. Don't sign, say, or agree to anything without a lawyer present. That's the basic Know Your Rights. The ACLU is a great resource for knowing all of your rights. And finally, why does this matter? Here's some thoughts from the Council for Nonprofits. Our society is better today because charitable nonprofit organizations operate as safe havens from the caustic partisanship that is bedeviling our country, places where people can come together to solve community problems. Repeal or revision of this law would damage the integrity and effectiveness of all charitable nonprofits and foundations. Attempts to repeal or weaken the Johnson Amendment would have the effect of politicizing and thereby erasing the public's high trust in charities, houses of worship, and foundations to benefit politicians and paid political consultants. So again, we have someone in support of that separation of church and state. And there's plenty of support. The majority of organizations support keeping the Johnson Amendment and protecting nonprofit partisanship, as reflected in the community letter in support of nonpartisanships. This letter is signed by more than 5,800 organizations in all 50 states. And the Faith Voices letter, signed by more than 4,300 faith leaders, a separate letter signed more than 100 denominations and major religious organizations, including ourselves, and in letters from law enforcement community. In addition, and this one surprised me, 72% of the public support of keeping the Johnson Amendment in place, and nearly 90% of evangelical leaders say it's wrong for preachers to endorse candidates from the pulpit. So the short answer here, can we talk about politics from the pulpit? It's complicated. Will someone stop us? Probably not. But should we? Should we mix our political parties and our religious freedoms? Now, in the spirit of Thomas Jefferson and those cheese-loving Baptists, I would uphold our values of religious freedom and keep that as a wall or hedge of separation between us and the wilderness of the world and the garden of the church. And I thank you all for your attention. Do we have any questions?